Right from the start, the court sets a controlled structure, and that matters more than it looks. The judge is quietly signaling that this won't be an emotional free-for-all. Everything will be filtered through legal standards, not personal narratives.
At the end of the hearing, I'm going to give you both a chance to testify in the narrative. So at this time, Mr. Welch, you may call your first witness. Thank you.
Thank you, Your Honor. State calls Fred Enrique Fox. What is your full name?
You said it, sir. Fred Enrique Fox, sir.
All right. And I guess first of all, do you agree that your the amount you make for your job is about $9,165.87 per month?
Yes, sir.
And do you agree that the amount you get for your VA disability benefits is $4,085.43?
Yes, sir.
And are any of that non-service connected disability pension benefits?
No, sir.
All right. So briefly, why, in your own words, why do you want the court not to count your VA disability benefits?
Sir, in your honor, the biggest thing that my understanding is, for me, is that I'm not trying to run away from responsibility, because I'm not, and I haven't. I've been paying my child support nonstop, sir. And for the past several years, we haven't changed the amount because myself and the mother agreed that I've been supporting our daughter, been supporting our son, our daughter, and I've never failed for whatever our daughter needs.
Sir, just the VA disability pen. I'll get to the. We can get to other things, but the VA disability benefits.
Okay. Oh, so you're asking why
Yeah.
should not be included?
Why do you think it shouldn't be included in our calculations here?
Oh, sir, I honestly don't think that the VA should be included, because there's some disabilities that I got from the war, sir, and that's something that I think that is helping me go through everyday life, from work and taking care of my family and everything else. And that's why I don't think that, and that's why I think the amount went so high, because I got my disability. So I honestly don't think that that should be counted due to disabilities that I got when I was in the military, sir.
All right. And do you have any other issues with the order, sir?
What do you mean, any issues, sir?
So is your only issue that you don't like that the VA disability is counted, or are there any other issues?
Oh no, yes, sir. I honestly think that I go above and beyond every time I'm supporting my daughter. So I don't think that it should go up at all, sir. Because I have a lot of, I wrote a whole statement. Yes, sir.
What do you mean by financially support your daughter? Like what are you saying there?
Okay, so what am I saying, sir, is that every time my daughter has needed something, I have paid. And when she's with me, I never ask the mom or any other person for anything. But when she's with the mom, she needs her nails done, her hair done, or this done, they always want 50%. They always want half for me to help. I went out of my way. I even bought her a whole bedroom set, not for my home, but for her mom's home. This is what I'm trying to say, sir. Like, I've done my part as a dad, been present and supported nonstop. Doesn't matter if I take her on vacation, I never ask for help, for money. I buy things for her. I never ask for anything. Example, my daughter called me, said, "Dad, I need help for volleyball." I went out of my way. We found help for her to get better. I never asked for help. I never asked for nobody to help me. I did it on my own. That's what I'm trying to say, that I feel like I've gone above and beyond helping my daughter, helping both of my daughters. And I never asked for support. I never asked for help. But a couple of days ago on Friday, they said that Ms. Wright said it was okay not to include the VA. And now she changed her mind. We're about to sign and she changed her mind again on Monday. So my question is, what happened? And why does a 14-year-old...
Sir, that's not her decision. Technically, she can't tell the court either. What I can
yes, sir.
I look at, sir, it's the law.
Yes, sir. Yes, sir. No, sir. I understand 100%, sir, the law, sir. I'm not avoiding the law at all, sir. Not at all, sir. I understand, sir. Black and white, I understand, sir. All I'm asking is for a revision, sir, to see what I have been doing as a dad, sir, and what I do every single day for our daughter, and that I have never failed her. I've never failed to pay. I've never failed to be there. That I have supported my daughter above and beyond, because when the other parent was not there, for example, she was moving or whatever it was, and I needed my daughter to be safe for our kids, I was there. I helped move. I helped buy a car, helped buy for tires. So I've always been there. That's my thing. I've always been there, sir. When she lost her job, she wanted to start a new job. I was there to help her start a new job. So my financial
All right,
support has
all right,
never
Mr.
stopped.
Fox.
Did I say something wrong, sir?
No,
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 sir.
no, sir.
It's just that the state and the court need. If you have any legal basis other than sir, what you're saying are obviously factors, but they're not legal factors to why the court should do what the court needs to do as far as what I need to look at, sir. So do you have anything else that you want to tell the court as far as a legal factor that I can consider also?
No, sir.
Yeah, sir. Everything you just said is something I can look at
Yes, sir.
for child support and deviating if necessary. But
Yes, sir.
like I said, it only gets you so far. I need to know if
I
there's
understand,
anything
sir.
legally you're requesting, sir.
No, sir. There's nothing legally, sir. It's just the stuff that I do, sir. That's the father.
All right.
Yes, sir.
Thank you very much, sir. We'll be back in just a moment again.
Yes,
and
sir.
I'll let State call your next witness, please.
Thank you, Your Honor. State calls Jebelin Wright. What is your full name?
It's Jebelin Carino Wright.
And is it correct that Antonio Jaden Fox and Nicholas Enrique Fox, those children are no longer children?
Yes, sir. That's correct.
And have they already graduated from high school?
Yes, they're both in college.
So this proposed order, child support review order that you signed off on, are you still okay with it?
Yes, sir.
The mother takes the stand. The tone shifts from defense to calibration. She doesn't attack. She validates parts of his story, which actually strengthens her credibility. By admitting he helps financially, she removes the need for the court to question his involvement.
Pass the witness.
All right, then, ma'am. Anything else you want to tell the court before I give you both a chance to? Well, I'll start with you, ma'am. Is there anything else in addition you want to tell the court? Any kind of closing statement you'd like to make, ma'am, at this time?
I just wanted to say, yes, he is correct. We've never visited this reevaluation of finances. But last year there was an instance that came up about insurance, and it was kind of canceled midway through this child support meeting. And so this next year, when that financial review came up, and they asked if we wanted to do it, I said yes, because I knew whatever took place at that insurance meeting or the insurance negotiation, something was off, right? And I just didn't know what it was until we actually dug into our finances. So I will say, Mr. Fox does help me. I make $4,000 a month. And yes, if my 14-year-old daughter wants to get her nails done and I don't have enough money, I am going to ask him to help me. It's $100 to get your nails done, and I don't always have that. If she wants to do club volleyball and I don't always have the money, yes, he has helped me with half of those $3,300 club volleyball dues. So I will say, yes, Mr. Fox has been helping me in times of need. But for so long, I didn't know what his income was, and I left it alone because that's what we agreed upon. But honestly, with $4,000 a month, that's not much to raise a 14-year-old teenage girl. And he obviously knows that because he does get her at least once a month. And when he does have her, he's taking her shopping and feeding her and doing all the things. So I definitely appreciate that. But yes, the answer is yes, he does help me. If I go back to this very last weekend, I am a Christian woman and I feel bad, right? So the amount is drastically going up. So I felt bad. And I was like, you know what? I am going to negotiate. I am going to call him. We're going to talk about this, because after all that is said and done, he's never reached out to me to have this conversation. He's reached out to my children, even the older children, but he's never called me to say, hey, let's meet halfway. Let's do something about this so we don't have to be here and I have to miss work, right? I get it. We're all here. And And so I was like, you know what? I am going to negotiate. Let me call him and talk to him and see if we can meet halfway.
Okay, here's the deal, ma'am. I know you're not a lawyer, but under Texas law, you're not allowed to talk about negotiations with the other party.
Okay.
All right. Sorry about that. But
No,
again,
you're fine.
That's a concrete rule under law.
Yes,
Sorry.
sir. Yes, sir. But what I'm going to say is the reason why I didn't negotiate is because I called him. He didn't answer. I got a text message with a question mark, and also
Objection, Your Honor. You
Again,
already.
That's still part of it. The
Okay.
fact that the other side refused to negotiate or didn't negotiate, ma'am, that's still part of the negotiation.
Yes, sir.
So you're not allowed to testify to it.
Okay. That's fine.
All right. All right, ma'am. The child is what, 14 now?
Yes, sir.
And when she graduated from, what's her graduation date as of this for right now?
Parker Heights High School, 2030.
Okay, so we got another 4 years on this one. So okay, thank you. All right. Anything else, ma'am, you want to tell the court about the circumstances?
No, sir.
All right, then. Any other questions of this witness, Mr. Welch?
No, Your Honor.
Any other questions of Mr. Fox?
No, Your Honor.
All right, Mr. Fox, I'm gonna real quick, ma'am. What city do you live in?
I live in Parker Heights, Texas.
And where does the child go to school at this time?
Nolan Middle School.
All right, and where would she go to high school?
Parker Heights High School.
Okay, that's what I figured. All right, thank you. All right, sir. Mr. Fox, where do you live, sir?
I live in Round Rock, Texas, sir.
All right, thank you, sir.
Yes, sir.
All right, Mr. Fox, anything else you want to tell the court this time?
No, sir. I said everything, and thank you for your time, sir. I mean, you explained the law, sir, and I appreciate it. Like I said, I'm not trying to deviate or take away responsibility at all, sir.
Sir. All right, Mr. Welch, anything in closing, sir?
Your Honor, so just so that you're aware, so our last order, basically set current child support amount of the original amount before any of the children emancipated was about $1,098 per month. That began June 1st, 2019. With the step downs, that has now gone down to $702 per month. And that last one started June 1st, 2023.
This is where the case becomes mechanical. Past orders, step-down amounts, and the jump to nearly $1,945 create a clear trajectory. The increase isn't random. It's the result of updated financial data and fewer dependent children.
And then the cash medical, there was cash medical, and that is $107 per month, starting June 1st, 2023 as well, after step downs. And there was also cash dental as well. $31 per month starting June 1st, 2019, but there was no step down, so that's remained the same. The new obligations, Your Honor, are current child support of $1,945, and we set that as beginning April 1st, 2026. And then health insurance is through Mr. Fox at $157.81. And dental, it's health and dental combined, but that's the total amount. So we considered health being that and dental being zero. So his cash medical and cash dental will thus stop, and he'll just have to pay the current child support of that amount I told you.
1,945 is the requested amount, correct?
Yes, Your Honor.
Okay. All right, anything else, Mr. Welch?
I don't think so, Your Honor. Thank you.
All right, Ms. Wright, anything else, ma'am?
No, sir.
Mr. Fox, anything else, sir?
Sir, I honestly think that I have another daughter, so I would think that it's only equally. I would have to save 1960 or 19, whatever it is, for my other daughter also, to be fair. You know, I feel like 1950 for a 14-year-old is a lot of money, because I mean, she doesn't pay rent or housing or anything, and everything that she needs, her mom and I go half. So that $2,000 puts a big bind on me that I can't freely support her or do anything when she comes to me, when she wants, Dad, I want extra shoes, or I want another private for volleyball, another private for this, it ties my hands more, sir, because that amount is more than my rent. So I mean, it's hard, sir. But like I said before, sir, I'm not trying to run away from responsibility at all, sir.
All right, and the other child you have, sir, did that child live with you, or is it with her mother?
Sir, so I have a week on, week off custody, sir. So I have her a week, and her mom has her a week, sir.
All right,
Your Honor,
I'm sorry. I know you're getting credit. I said, which county is that out of?
It's Williamson County, sir.
Okay, thank you.
Yes, sir.
All right, guys. I sure hate to do this, but again, your file. Yeah, well, it's not terribly thick, but I do need to go over it and look at a couple of things as far as the dates and since the last thing and how much has been owed and all that kind of factors in on how I'm going to try to set this up. But at this time, I'm going to go ahead and I'm going to try to get a ruling out to you guys before the day's up. But I got a couple of hearings I need to take care of. And I want to go ahead and try to read over the file again. It's not. I thought I had this other file. And this other file is 3 times thicker than y'all's. But I do want to look at some times and dates on this and what I'm looking at going forward. So anyway, at this time, I'm going to go ahead and if y'all want to, y'all can leave. Y'all can check back in, or if y'all want to check back in somewhere after 3 o'clock. I should have a ruling by, well, let's go ahead and let's make it after 4 o'clock. That'll give me probably time to look at this and look at the entire file before I come up with a ruling. But again, I'll look at the factors y'all have all testified to, see what the fair and equitable amount should be. And I'll make that ruling, like I say, about 4 o'clock this afternoon. If y'all want to log back in and take that back up, I'll go back on the record and give you the ruling, okay?
So do we call back in at 4, sir?
Yes, sir. You can log back in if you at 4 o'clock, and I should have a ruling ready. So you'll as soon as whatever hearing I'm doing at 4 o'clock, the next one after that will be yours as far as the ruling is concerned. If y'all are not here, I'll just let the state know what the ruling is, and they'll send it to you by letter. Okay.
Yes, sir. Thank you, sir.
All right. Thank you both very much. I don't want y'all just hanging around here all day, but y'all can go ahead and leave at this time unless the state needs y'all back and break out for something else.
All right. Thank you, sir.
Thank you.
Mr. Wells, you need them back and break out for anything?
No, Your Honor. I should just let them know that if they don't show up later, what I'll do is I'll DocuSign them. Basically, first the findings page that says what happened today,
Okay.
and then attached to it will be the order itself. And if judge makes any changes, the changes will be there, and then y'all will just sign off. I'll just only have y'all sign off on the findings page.
Is it mandatory to show up, sir? I got to drive
No,
to
you
see
don't
my
have
daughter's.
No, sir, you do
My
not.
daughter has an award ceremony today. That's why.
Okay. No, sir, you do not have to show up. That's why it's
Okay.
your option. Okay.
Okay. Yes, sir.
Thank you.
And
Thank
again,
you.
when I DocuSign it, sir, you'll get
He
an
introduces his other child, shared custody, and lifestyle impact, trying to show that the new amount restricts his ability to parent freely. It's a relatable concern, but again, doesn't override statutory guidelines. The judge's response, delaying the ruling, shows caution, not uncertainty. He's not convinced by argument, he's verifying data. That distinction matters. The decision will come from the file, not the testimony. The closing moments reinforce the court's role, not to validate feelings, but to produce an equitable outcome based on law and numbers. Everything else is secondary.